Article 20 for its public stockholding program. I hadn't thought of that. I'm just worried about, I'm sure you've heard of the analytical index WTO, which is this big, which is this big, and the chapeau of Article 20.
Yeah.
So, but I'd like to think about it. It's a fascinating line of thought. I just wanted to briefly say that one of the most dramatic moments in the WTO, I mean, just following up on what Pallavi was saying, was in the late 90s, the entire 90s, I would say, when we had an AIDS crisis in Africa. You know, the AIDS crisis when people were dying. So we came up with a slogan in the WTO, patents versus patients. You know what I'm saying? So Oxfam said that actually. And we were able to actually, and I don't want to take too much time because I do want to leave a bit of time for questions. We have one more speaker. So we had a long debate, and short of amending the TRIPS agreement, we came up with what is known as a ministerial declaration on TRIPS and public health. Somewhat immodestly, I can say I was very, very closely associated with that. We couldn't amend the TRIPS agreement because the developed countries would never accept it. Big Pharma was sitting on our heads in Doha as we were negotiating, and for them it was very, very difficult to accept any derogation from TRIPS. But I think what we really did was fantastic, because we slightly shifted the balance. You know, this balance that you have in the TRIPS agreement between legitimate reward for invention versus what is known as a public good, that is access to medicines and access to technology and so on. I think we were able to get some balance. But I like your line of thinking. The trouble is what James says, that there are only a couple of cases of Article 20 so far. One should look at the chapeau, and I agree with you. I think countries should try to use that. I will be attending a conference shortly in Singapore on the same subject, WTO, and it's very unfortunate that public stock holding, of all things, has been picked by the developed countries to kind of beat India with, because that is one thing which does not distort international trade at all. What is the distortion? India is not a big exporter of anything, frankly, and in agriculture. I don't want to talk about other things, but in agriculture we are not a super exporter. So what international trade are we distorting? So I think that is a debate, but I like your line of thinking. I think that's very novel, at least I haven't heard about it. The last word to Professor Ranjan. You have the floor, sir.
Let me first very clearly sort of state my own position on this, which is somewhat reflected, somewhat sort of resonates with what James said. I also believe that to realize human rights, you need a market economy which is based on liberal democracy. In any other country which is not based on a market economy model, where the state drives the economy, where you have public sector undertakings, etc., where there's too much of opaqueness and functioning in the bureaucracy, I'm not very sure how those countries provide the right conditions to achieve human rights. So I do see a very strong link between human rights and economic liberties in that sense. Maybe Professor Jaiti Ghosh would have disagreed with me.
Now, China proves your point, actually.
Yeah.
Go ahead.
Yeah. Now, coming to this, I'll go back in time to 2004, 2005. I don't know whether Professor Marx would remember this, but there was a conference at JNU at School of International Studies where we discussed the issue of trade and human rights. And I dropped you at Professor Sengupta's residence after the conference in my car. So it's quite appropriate that we are discussing this again in his presence in that sense. And at that point of time, we had this entire debate of patents versus patients, because that was the time when India was amending or had just amended the Patent Act and had introduced the product patents on pharmaceuticals. And of course, this concern was that the moment we do this, the prices of drugs will go up. And, India did find a clever answer to that by saying that we will use the flexibility in the TRIPS agreement and define patentability and inventive step in such a manner that we will ensure that there is no evergreening of patents. Nevertheless, concerns were expressed that this law will be challenged in the WTO's dispute settlement body by countries like US under the pressure of big pharma companies. But fast forward to 2018, in the last 13 years, it is very evident that no single challenge has been brought against India, challenging the Indian Patent Act as being inconsistent with the WTO agreement. So in 2005, when these concerns were expressed, and maybe for right reasons, time has at least shown that some of those concerns were exaggerated, because the Indian Patent Act is very much there. The constitutionality of it was in a way attested in the Natco versus Bayer, and even in the other case by Supreme Court, and no such challenge has been brought against India. So the question of conflict between, say, protecting intellectual property rights of a pharmaceutical company along with the right to health of people, I'm not saying that debate is not relevant, but I'm saying that debate is perhaps exaggerated at times and is perhaps not borne out by the empirical evidence that we have. Now, this brings me to the first point that I want to make, that how do we look at this entire debate on trade and human rights? If we use the conceptual framework that Joost Paulin has developed on conflict of norms, we can say that this debate is basically on the question of conflict of norms. That is, on the one hand, WTO or other free trade agreements impose an obligation on the countries, and because of this obligation, two things happen. Either these countries give up their human rights norms, maybe under health or environment or labor, or if they implement the trade obligation, then they are automatically in conflict with their human rights, environmental or labor regulations. Now, this concern, again, to a great extent, in my view, is exaggerated. I used to believe that Professor Petersman was wrong when he wrote that paper in 2005. And of course, Indian government continues to believe the same thing. But over a period of time, as I sort of read and matured, I realized that what Professor Petersman was saying was correct. There is actually no conflict. And even if there is any apparent conflict, there are mechanisms available in public international law how you can address those conflicts. Pallavi talked about Article 31.3c. I'll very briefly talk about Article 31.3c. One point which Pallavi did not mention. Article 31.3c has been hailed by the ILC as a tool of systemic integration. As James mentioned, that WTO is not a system which is born outside of public international law. It is very much a part of public international law, and therefore you can actually integrate the WTO legal regime or the free trade agreement or any treaty for that matter with other international law in the form of treaty, custom, general principles of law. And 31.3c can play a very important role. I will not repeat what Pallavi has already mentioned, but there's one very important point when she talks about applicable in the relation between the parties. That is, the appellate body for that matter can take into account any rule of international law which is applicable in the relation between the parties. The question is that what do we mean by parties here? Do we mean the countries which are party to the dispute, or do we mean the countries which are members of the WTO? So in other words, there's no consensus. There's actually divergent opinion on this. One view is that parties in 31.3c means countries which are party to the dispute. So if India and US are in dispute, then any human rights or environmental treaty to which India and US are a party will be a relevant rule under Article 31.3c. The other interpretation is that parties in 31.3c actually means all the parties who are signatories to that treaty. Now, if we accept this interpretation, then it would mean that all the 164 WTO member countries have to be signatories to an environmental treaty for that environmental treaty to be a relevant rule under Article 31.3c. Now, which interpretation do you adopt will decide on to what extent there can be systemic integration. The other way in which
mention one point here. So Article 31.3c is basically part of customary international law, right?
Yes.
Even if it is a particular country hasn't ratified the VCLT.
No, absolutely. That's absolutely correct. VCLT is a treaty, but the rules of treaty interpretation are part of customary international law. So this is an argument which is often made for India, for example, that India is not party to VCLT. That will not make a difference as far as rules of treaty interpretation are concerned, because they are part of customary international law. The other the second point which I want to make in terms of how do we try to resolve this apparent conflict is through treaty language. WTO has struggled to achieve that. Maybe the Doha Declaration on TRIPS and Public Health was one step in that direction. You could not amend the TRIPS agreement, so you could at least adopt a declaration, and then that declaration is like a subsequent agreement within Article 31.3a and 31.3b of the VCLT, which then becomes an integral part of the agreement. So it will more or less try to solve the problem. But a better way to address that problem could be that by having very clear treaty language, and some of the free trade agreements, for example, are a good example of this. I'll borrow on the work of Professor Lauren Bartels of University of Cambridge, who has written extensively on this. And he has tried to document how many free trade agreements signed by Europe and Canada have actually used human rights language in the treaty itself. And he gives several examples. I'll just give you some examples. For example, if we look at the Canada Comprehensive Economic Trade Agreement that Canada and European Union have signed recently, he gives examples of two kind of provisions to reaffirm their commitment to honoring labor and environmental laws. The first, he says that there's a provision which says each party agrees not to waive or otherwise derogate from or offer to waive or otherwise derogate from its labor law standards to encourage trade or investment. So basically the commitment is that we will not derogate from our environmental norms, labor norms, just to encourage trade, the kind of race to bottom kind of approach. The second is, they say very clearly that there will be, through a sustained or recurring course of action or inaction, fail to effectively enforce labor laws and standards to encourage trade or investment. So we will not be lax in enforcing labor laws or environmental laws just to encourage trade or investment. Now, the moment you put something like this in the treaty itself, which I don't think the Indian government will agree, the Indian government still thinks that human rights should not come as part of a trade treaty at all. An approach which I do not understand to what extent it is relevant in today's world. But these are some of the examples which you can put in the treaty to ensure that while you are committed to international trade or liberalization of trade, at the same time you are also committed to human rights obligations in the form of environmental law or labor law regulations. I'll very quickly, last point, talk a little about investment, because I think one cannot divorce trade from investment, and especially in most of the free trade agreements that we have, investment chapter is obviously a very important element of it. James mentioned about the Philip Morris case. This case happened not just at the WTO, even at the investment level. There was a case that Philip Morris had brought against Uruguay. And a point which is not often highlighted, especially by the critiques of the investment treaty regime, that the investment arbitration tribunal, which actually works in a far more murkier way than the WTO appellate body or the WTO panel does, this investment treaty arbitration tribunal actually reaffirmed the right of Uruguay to adopt regulatory measures for the pursuit of their protection of right to health. And they did not award damages to Philip Morris. Similarly, in the CETA, which I was talking about, there is a very important article known as right to regulate, and that article very clearly says that the member states, that is European Union and Canada, reserve or preserve their right to adopt laws and regulations in order to achieve their social objectives, health objectives, so on and so forth. If you look at the Indian model bilateral investment treaty, you would find some references to something like this, the right to regulate being reasserted. But for some reason, as I mentioned, I'm not able to understand why this right to regulate is not reflected in the trade agreements which India is party to. I think from what Mr. Mohan Kumar mentioned in his introductory remarks, I think the concern has been throughout, including in shrimp turtle case and other cases, that if we bring in human rights as part of the trade discourse, then developed countries will use human rights as a pretext to deny market access to our products. In fact, that was one of the arguments in shrimp turtle case. If you read the writings of, say, Professor Chimney on the shrimp turtle case, he also makes this point that then human rights would become a pretext to stop and deny market access to products of developing countries. This concern was relevant maybe 15 years back when the WTO was just born. But over a period of time, when we have so much of jurisprudence on Article 20, I do not think, and the difficulties of passing the Chapeau test actually prove that, I do not think that it will be very easy for a country to use human rights as a pretext to deny market access to a particular country. So I'll conclude by saying that perhaps developing countries and diplomats of developing countries need to have a relook at the position that they have taken on trade and human rights in view of the fact that they are actually two parts of the same coin. Thank you.
Thank you very much, Government of India. I'm not part of the government anymore. But I will say this much, and not to be immodest again, but I've served in 12 GATT dispute settlement panels as a panelist. See, one thing that we are adamant, and I remember arguing with the GATT secretariat about this. When you talk of the link between GATT law or WTO law with BCLT and other, parts or bodies of international law, the WTO trade diplomats are very particular about lex specialis. We are very clear in our minds that it doesn't matter when an agreement is concluded. There is also another rule of international law. I realize I'm sitting among legal luminaries. I'm not a law, I don't have a law degree. But there is also one principle, which is that the latter law takes precedence over the previous law, whatever you call it. Second is lex specialis. But for WTO negotiators, lex specialis is an article of faith. We will never, never, ever accept that there is a body of law. Because the rest of the law, sorry, but a WTO negotiator will say it's blah blah. You don't have dispute settlement. We are the only guys who have dispute settlement. The only enforceable law in the world is WTO law. It's another matter that it is being wrecked today. That's a different issue. But so far, you tell me one, and that's why we make a distinction between hard law and soft law. And you guys are mixing up both. You're bringing soft law into hard law and saying that you will use the dispute settlement mechanism of the hard law to implement soft law. Never going to happen. WTO guys will never allow it. I'm also being partly provocative, just have fun, while we wait for lunch. We can do that, and I'd love to hear what young people think about this. But this is the view, not of Government of India, I underline, but just the view of a, shall we say, hardcore trade negotiator. Because we negotiate in WTO within a certain framework, we are not, and we've tried that. India has tried that as well. We tried, for example, SDGs. I personally have a strong view that SDGs should trump trade law. What is the use of trade law for me if I cannot achieve my sustainable development goal of no hunger, no poverty? What am I going to do with trade law? But they will never accept it. I'll be laughed out of the sort. You didn't like my speech? Okay. I'll stop here and we will have questions. Please introduce yourself, which department, what are you studying, etc. Yeah, please.
My name is Vijay and I come from Jindal School of International Affairs. I don't have a problem with any of the words used here, but I experience all these four words: tariffs, trade, sustainable development and human rights. Because I'm an agriculturist, okay? I come from the Western Ghats. We grow coffee, that's it. We are into hardcore agriculture and we grow coffee. What happens is that all my laborers are from Assam, or the staff who work for me. The thing is that every year what happens is that there is a fluctuation in prices. Solely because we import a lot of coffee and a lot of agricultural commodities because of SAFTA. And last year the price of pepper, 1 kilogram was 700 rupees. This year it's 280 rupees, solely because we import inside. So the problem is that every year my staff asks me why are our salaries fluctuating. Because when you import into the country, I don't have the money to pay my staff. Next point is that sustainable development. Honestly, if you look at agriculture, all we do is that we plant as many trees as possible. But every time there's a repercussion, we are the first ones who face the repercussions of nature, floods. I'm sure you all saw this year what happened. Next thing is that because of these tariffs and trade, we feel like who is responsible enough to do something for agriculturists? Who actually does things for us? Because the Commerce Ministry does nothing, the External Affairs, I don't know if they're responsible for it. So I'm just interested in knowing who will take care of the agriculturists in India who barely have any idea about how WTO works or anything. At the same time, we face repercussions because of how goods are imported into the country and why we face price fluctuations.
So Vijay, explain one thing to me before I give it to my illustrious panel to answer at least some of the things. You're raising very fundamental issues, I realize. Why do you automatically assume, you said you grew pepper.
Pepper, coffee.
So let's take the example of pepper.
Yeah.
Imports of pepper automatically is bad for you because your cost of production is high? Is that what you're saying?
So,
I want to understand why prices dropped from 900. I'm assuming the Government of India imports pepper because of an assessment that there is going to be a shortage of pepper in the country. I don't think the Government of India would do it for the kick of it, right? So can you please tell me why you are so bothered by imports? Is it that your cost of production is way too expensive compared to the imports?
So whenever it's imported, sir, especially from Sri Lanka, what happens is that there's a glut in the Indian market itself, sir. There's a glut in pepper in the Indian market. So what happens is that the people who buy from us or the lobbyists, what they say is that there's already so much available in the market. We don't want to give you high rates. So, that's what happens.
So this doesn't, on the face of it, it doesn't make sense. If I was part of the government of India, and this is the Ministry of Commerce, by the way, they should be making an assessment, and you would know well in advance whether there is going to be a shortage. I mean, pepper is probably a wrong example. I mean, it's not such an essential thing. But if you take, for example, food grains or sugar or salt, those are much more fundamental. And I would assume the Ministry of Commerce will import only if there is a shortage. Of course, we have a tariff schedule, and my recollection of India's agricultural schedule is that it's pretty high, the customs duty. The customs duty is not 8 or 10%.
So under SAFTA, they're allowed to bring in, sir, under the South Asian Free Trade Agreement.
Does it come under 0%?
Yes, sir. They bring it in such a way that even though, for example, Sri Lanka has a certain amount of commodities, how much they can get into us, if Sri Lanka is not able to produce, countries like Indonesia and Vietnam, they route it through Indonesia and through Sri Lanka. And
So, but Vijay, this is what I'm saying. I mean, including freight and transport and clearance at port, if that pepper is still going to be considerably cheaper than yours, I don't know what to say. What is wrong with Indian soil and our techniques that we are going to make it so expensive? I mean, it has got to come all the way from Indonesia. It's transported. Obviously, it's insured. Then it comes to the market. And you're telling me we can't face these imports? Is that what you're saying?
So what I'm putting across is that the price that we're getting, sir, in India, for example, let's say when we're supposed to get 700 rupees, it includes certain things like how much of the wages we are paying for labor here and all that, sir. In a country like Indonesia, the labor cost is genuinely cheaper for them, sir. So when they route it...
Labor in Indonesia is cheaper than labor in India?
Sir, here it is quite expensive, sir. We pay about 600 rupees per person.
You should have told that to Professor Jayati Ghosh, yeah? We are talking about people being absolutely unemployed, and you are telling me... it doesn't tally, but I leave it to my panels. I don't want to take this. I understand, Vijay, because the angst of farmers is something that I have not been able to understand, but I fully realize what you're saying. Professor?
Yeah, on a lighter note, I'm quite happy to hear for the first time that actually SAFTA is increasing trade. Because I think it's the most atrocious agreement to be signed, and the word free should not be there. It should be South Asian Restrictive Trade Agreement or something like that. It has actually not, the intra-regional SAARC trade is not even 5%, which is horrible if you compare with what EU does or what ASEAN does. But at a more serious level, I think the problem that you mentioned is the usual problem that we have with free trade versus what impact it has. And I think what is important is that if tariffs are being set at a particular level, and despite the tariffs being at that level, if still people are able to export that particular product to India, then I guess there is the need is to relook our own productivity, our own techniques of production, so on and so forth. Because at the end of the day, we have to compete in the global market, whether we like it or not. I mean, that's one way to put it. I would very briefly like to reflect on what you mentioned. Actually, if you look at human rights treaty, environmental treaties, labor treaties, they're not soft law, they're treaties, so they're hard law.
So how are they enforceable, tell me? I go by enforceable. We all know the track record of how long it takes and what is going to come out of it.
But simply because it
enforcement is not a characteristic of hard or soft law.
Yes, I mean simply because...
What is the characteristic?
The wording of it, the codification.
Whether it's a treaty, if it's a treaty, it's a hard law. Even if there's no mechanism to enforce it, it does not make
So we have a fundamental disagreement. I would say that, anyway. Please, sorry.
So, no, absolutely.
This is what happens when a non-lawyer starts talking law. Go ahead.
So what I want to say is that, I know that I've spoken to many Indian negotiators and many developing country negotiators, and they often think that WTO is kind of a system which exists in clinical isolation. It was the very first appellate body report which had clarified that's not the case. And therefore, more and more appellate body reports have actually referred to the Vienna Convention on Law of Treaties. And therefore, it is very difficult now to make this argument that you cannot look at law which is outside the WTO law, because that will be going against the very basics of public international law on which the entire system is built. So we'll have to look at some better arguments if we are actually keen to counter that point of view. We'll have to look at some other arguments to do that.
No.
Sorry, Anurag.
Can I?
Please.
Yeah. No, I think just to actually there are 2-3 points I think which has come from Prabhash's point and your point. But to kind of very quickly summarize, my assessment of what is hard and soft law is on the text of the treaty itself. So Paris Agreement for me, which actually says that it is an intentional national contribution or an INDC, is actually in the realm of soft law because it is what the country reports it would do. The reporting and verifying mechanisms are completely soft, and there is no actual real way to enforce it. On the contrary, the Kyoto Protocol actually was hard law because of the fact that it imposed binding obligations on emission reduction, which the US did not undertake. So obviously it's not binding on the US. But we did not exercise that agreement against the country. Of course, EU was one of the biggest countries which complied with it in letter and spirit. But there were other countries that did not, and like Japan, for example, we probably had the option of initiating theoretically a case, which we did not. So it really depends on the letter of the treaty. There are a number of obligations in WTO law itself, which would trade facilitation agreement, I'll tell you, is the biggest example of 90% soft law and 10% enforceable obligations.
Of course.
Because a lot of it is endeavor, practicable obligations.
S&D itself is a good example,
But just to get on to the point that you make, a fascinating point, very interesting point. Very quickly, I think the point on trade diversion, where you're saying Indonesian pepper is actually coming masked as Sri Lankan pepper, for me is a bigger concern. Because it's a failure of trade mechanisms to actually enforce rules of origin, because the product has to genuinely be from the country with which you've entered into an FTA. That apart, I think the fundamental policy-related issues on competence, on actually getting more of comparative advantage, and perhaps the other bigger question that I have is, what countries like EU does before entering into an FTA, which we don't do at all, is a sustainability impact assessment, a SIA. Prior to entering into the FTA, what is the benefit that FTA is going to bring in is crucial, has to really again be built into our policy itself. But having said that, very quickly, if I can reflect on a couple of other points that had come. As far as right to regulate, Prabhash, is concerned, it is actually embodied in WTO law. Right from the preamble to the Marrakesh Agreement, the preamble to the GATS Agreement, the TFA itself, and the SPS and the TBT agreements embody that right to regulate. The other issue is that, from both your points, I think the issue is really not about the fact that, clearly, I think we are way beyond the point that WTO law exists in clinical isolation. WTO panelists have to a large extent taken a little bit of a conservative view, but the appellate body has opened that, as Prabhash said, in the very first case, it said the gasoline and the shrimp turtle, where it has actually said that, no, you have to read it with the other bodies of law. The issue really, however, is whether a trade instrument is the best instrument to enforce human rights or labor or environment. Because taking from the shrimp turtle case itself, US would have just got away with imposing a ban, which the facts clearly show were really for a protectionist purpose of protecting US produced shrimp, or the tuna case for US produced tuna. The organization that stepped in, which the WTO was completely ill-equipped to do so, was UNEP, which actually enabled countries with giving the training, the technical and capacity building, and the financial assistance to procure fairly expensive turtle excluding devices that could have actually protected the turtles. So the issue really is not that WTO law of trade versus human rights. They coexist. It's about which is the agreement that is best suited, which is the organization that is best suited to achieve your objective. WTO will simply achieve a ban. It will not address the purpose of protecting turtles. And again, coming to issues like what Dr. Kumar said about a $16 uniform regulatory harmonization of minimum wages between US and Mexico, which goes completely against the overall comparative advantage theory. It is not that pay the Mexican cheaper wages, pay the Mexican minimum wages as per ILO standards, as per existing human rights standards. It's not a question of paying them lesser than that is going to violate human rights, but ensuring that they pay a same wage in effect has scuttled the trade opportunity or the comparative advantage that auto industry would have had in Mexico itself. I think that's the real issue. And again, very quickly coming to Pallavi's point on public stockholding, I think the bigger issue, sir, would be that the agreement on agriculture is lex specialis. is the GATT has Article 20. Now the bigger issue is, does Article 20 apply to other covered agreements? That will be the big issue. But having said that, the AOA itself has enough and more policy space, which willy-nilly developed countries have used much more. As you said, the type of subsidies that we give are considered to be AOA, Agreement on Agriculture compatible subsidies. Why is it that we can't do it? It's more a question of, how we have walked into the export subsidies case at the WTO right now, which James can actually talk about a lot more. We can restructure our subsidy schemes to ensure greater sustainability, greater productivity, rather than having an age-old scheme that will fall foul of WTO rules. I think that is the bigger problem.
Thank you. Yes, James, please.
In fact, I completely agree with Vijay, because I also come from Western Ghats, right? Actually one thing, because this is a genuinely real problem. So the prices of a large number of commodities are extremely volatile.
Industry is going through a certain kind of a distress. Under the safeguards agreement, you can get some kind of a relief. But again, the problem is that it has to be an organized industry. 10 or 15 or 20 people cannot go to the safeguard authority and seek some kind of a trade remedy action. Because they would say, give your cost of production, give your accounts, your income statement, and these are all very poor farmers. And secondly, the point is, when the prices are actually very low, right? Sometimes some of the purchasers engage in anti-competitive practices. They buy the product, artificially depress the price, and then stay away from the market for a long period of time. So the poor, this is actually a major issue. And the poor farmer cannot go to any kind of an authority and seek a relief. They will dismiss the case. Secondly, if you look at some of the agriculture sector, I'm very familiar with the case of coconut. So in the central part of Kerala, Kerala was very strong in coconut production and export. There is a huge problem of root wilt disease.
What disease?
Root wilt. So this kind of disease is basically wiping out the entire plantation. Who can actually provide a solution? Only some of the scientific universities, the agriculture universities will have to do the research, and they haven't done anything. So again, I think these are factors where the government will have to support the scientific institution, the agriculture institution. The comparative advantage is not actually limited to the poor farmer alone. The whole ecosystem will have to improve. And that is why I feel that all developing countries have got this kind of a problem, because they do not have universities providing the kind of support. While coming to the second issue about the Vietnam, the circumvention. Some of the countries, including Vietnam is actually non-market economy. It is a communist, I don't think that they have got market economy principles. So the allegation is that the cost of production in that country is extremely low. And they are able to produce the product at very cheap cost, and then able to take the benefit of the India-Sri Lanka Free Trade Agreement. So they do some kind of a value addition in Sri Lanka, but the problem is that our customs authorities are unable to actually track and find out the extent of valuation, and to find out whether this particular exporter is trying to misuse the provisions of the FTA. So that is why we need to have all these kind of domestic institutions in the country, right? My last point is actually on the issue of WTO and right to regulate. So if you look at all the recent WTO cases, they are no more GATT Article 3.4 cases. They are either SPS cases or TBT cases. So the right to regulate is basically part of the WTO system in Article 2.1 of the TBT agreement or the entire SPS agreement 3.1. And again, the most important point is that WTO is not actually the agency that is regulating. The most important regulatory activity is happening in the standardizing bodies. So you may look at the Codex Alimentarius Commission. You have to look at the World Organization of Animal Health. These are the bodies that are actually preparing the standards, and once a particular member adopts an international standards, then it actually becomes a WTO consistent measure. So the real rulemaking is not happening within the WTO. There's a huge amount of, let me tell you again, these are completely undemocratic entities. I'm very familiar of ISO standard making, and when ISO actually makes a standard, it is not based upon a consensus principle. Some of the really powerful countries are able to push their standards and make them international standards. So these are absolutely right. Yeah.
Thank you. Any other question? We have 15 minutes. Yes, please.
So my name is Rohan. I'm in the Masters International Affairs program over here. I'm not a law student, so I obviously don't have that much knowledge about law. But I have a question regarding what we saw today. We're talking about trade and human rights, two things which I never, as an international affairs student, I don't think it ever come together, because trade is nothing, but trade always has some deep self-interest or profit maximization, and because of that, human rights will never be taken into consideration because, well, all these institutions like WTO, GATT and all that, they're only bringing countries to come trade freely, but free trade is also never free trade. Any powerful nation is always going to impose its like laws, not laws, but like it's going to impose its values on the other. So whose human rights are we to take? China is always going to say that I'm a sovereign nation, my definition of human rights is different than your definition of human rights, so why should I ever accept what you are saying? So when it comes to like trading human rights, I'm not able to get the link of how they're going to work, because one is a more liberalist approach and one is a more constructivist approach. So how is it going to like ever come in consensus?
So this will require a separate conference all by itself, lasting 2 days. But no, you've raised some profound issues. My limited answer, I think you'll have to think of trade and human rights as dynamic concepts which are evolving. That's the only answer I can give you. I think you sound like the concept of what trade and human rights was in the 19th century. It is evolving. Trade is evolving, human rights is evolving. That's what we heard. And I thought you heard James present this fascinating theory about being the two sides of the same coin. You can disagree with it. I'm skeptic. I don't disagree, but I'm thoroughly skeptic. Having been completely brainwashed by 10 years at WTO in Geneva, that can happen. You know, we fall into our own kind of spheres as well. But I think having said that, you should have an open mind and see that these are dynamic concepts. And I do not believe you should completely be close to the idea that they can meet at some point. I'd like you to keep an open mind on it. It seems that way, but I think that's the way law is going. So, any other question? Yes, Professor Stephen Marks.
I've been enjoying this very much, but I can't resist jumping in at this point because I think Rohan put his finger on the problem very well, which you raised in your opening comments. You put it in terms of liberalism and constructivism. That might be a good way of interpreting what the essence of the international trade regime is compared to the international human rights regime. Might be, but you'll agree with me that it's also kind of trying to encapsulate in a sort of an oversimplification, because you can have other theories of international relations to explain the human rights regime and other theories of international relations to explain the trade regime. But the two thoughts that occur to me that have come up several times here are that of what we call in Geneva, where you spent so much time, policy coherence.
Yeah.
You and your colleagues come from ministries of finance, Ministry of Civil Aviation, in other cases, ministries of trade, with their background training instructions from their authorities, and their experience and their disciplinary background is very essential to that. Those who are further down the road, Pally Wilson, come from the Ministry of Foreign Affairs with the specialization in human rights. And their expectations, their framework, their daily work is quite different. And they draft resolutions on trade and human rights. They draft resolutions on human rights impact assessments to be applied in the case of trade. They adopt resolutions on intellectual property rights, the TRIPS agreement, the Doha Declaration, to be applied in ways that are consistent with the human rights obligations of states. So the question that we've often raised, and this came up, and I'll bring it back to Arjun Singh Gupta again, when we were meeting in the Intergovernmental Working Group on the right to development and in the high-level task force with our colleagues from the World Bank and our different agencies, we confronted that head-on, the policy coherence, because in the right to development we brought together, and Arjun helped bring together, people from these different frameworks and sources of instructions in Geneva. And those who would go off to WTO because that's their job, and those who would go off to WHO because that's their job, and those who would go off to WIPO because that's their job, aren't aware of what their colleagues from the same government are doing down the hill at Pally Wilson. So that's the first point in policy coherence. The second policy I was alluding to earlier is that for the last 15 or 20 years, those working on this issue of how can these two regimes interact in a fruitful way have focused a lot of attention on human rights impact assessments applied to trade agreements. And there's a lot of experience and background in this that led actually to the adoption of a set of guiding principles on human rights and human rights impact assessments and trade. So things have come, there has been a lot of thought going into that. A point that's been raised several times in your interpretation of the treaty obligations and the Vienna Convention on the Law of Treaties has been particularly enlightening in this regard of complementarity of treaty regimes. Now, in the human rights framework, General Comment 17, the Committee on Economic, Social, and Cultural Rights, goes a little bit farther than most people are willing to go to say that intellectual property agreements are temporary monopolies for understandable reasons. Human rights agreements are supposed to be timeless. So when it comes to what verb can we use in place of Trump? We have to find another verb. When it comes to one regime prevailing over another,
Yes.
the case has been made that the human rights regime in case of conflict should prevail over the other. In other words, that when there is a legal obligation under a treaty to be interpreted under the rules that you're applying, in light of the ratification of treaties by countries, of accepting legal obligations in the human rights field, those human rights norms should prevail. So I couldn't help injecting those
Can I just mention one point?
Very
Just one
relevant. Yes, James.
point. You know, again,
and then
right. See, I do not see any kind of, difference between human rights and trade being part of the same coin.
you
So if
don't
you,
have a problem? Or
no, I mean, okay, I might have a problem, right? So what I say is that, if you look at Article 20 of the GATT, so the major problem is with the scope of Article 20 of the GATT, and what is it actually? It talks about there shall not be any arbitrary discrimination, there shall not be any unjustifiable discrimination, where the same conditions prevail.
Or disguise protection.
There should not be any disguise protection. These are actually, these are the principles of inner morality of law. So if you look at the work of Lord Fuller, who said that morality is not actually purely substantive, it is procedural as well. So when you make a note, every law has to be notified. So there is a transparency element within that. You have to inform the affected party about it. So due process is actually what you call as the inner morality of law. So whenever you violate the principles of the scope of Article 20, you are actually doing an immoral act. You are doing an immoral act. And it won't be justified by the so-called protection, Article 20 of the GATT. So the point is that once a country is actually sincere, genuine about protecting something, you can actually pass through the scope of Article 20 of the GATT.
Look, I mean, I'd like to believe all of you, but having worked in, I'll be honest before I give it to you, sir.
Right.
The GATT Secretariat doesn't play an intrusive role. No, I shouldn't be talking about it. Politically incorrect. They're all sworn to secrecy. By the way, I was one of the panelists on the genetically modified
I know that.
outcome. Yeah, so you can blame it on me. So the Secretariat said very clearly, you see, again when you see VCLT, if the language of WTO law is clear, we do not go outside that. VCLT does not figure even on the horizon. It is, and when you find the language in WTO law unclear, the next step that a panelist does is go to the negotiating history. Okay? You are still unclear, you go to ordinary meaning of the law. Having considered the negotiator's intention, first the explicit language of the law. Next, negotiator's intention. Third, Oxford Dictionary. You have to go by something. It's only when all this fails, I'm going to look at any other law. I'm sorry, I know I'm going to leave you heartbroken. No WTO panelist is ever going to look, and I'm on your side. I tried so hard for CBD to take precedence over TRIPS. It was thrown into the dustbin in the WTO. What are we talking about? You are conventional on biological diversity. Now, Pallavi, you will turn around and tell me that's hard law. Hard law, my foot. The WTO throws it out. What do? You have to go by the TRIPS law. That's the issue. But I'm going to give it to you as a last word, but the gentleman there, and then you wind up, Pallavi.
I just want to contradict you because you said that we look at the history of...
My question to Dr. Mohan Kumar. The Western countries in what we call neglecting the two aspects, environment and health, that's neglecting the sustainable development. Number one.
What are they neglecting, sir?
Neglecting the sustainable development, which includes human rights, that is health and environment.
The Western countries are neglecting it.
Yes, sir. My question to Ranjan, developed versus developing countries, in the name of human rights, they are not allowing the access of the goods of the developing countries to the international market. You please explain. Next to Dr. Nedumpara, the attitude of the USA, like World Police, they don't sign important international conventions. If they sign, they withdraw. You kindly explain what is the attitude, how to make them to come to the negotiating table or bend them. The last but not least, Pallavi, what is the effectiveness of the dispute resolution mechanism under WTO law, especially in case of the developing nations?
Pallavi, you go first.
The developing countries. Well, I
As
guess,
a whole, especially for developing countries.
okay, well, the main, the WTO dispute settlement mechanism is known as the jewel in the crown, and it is supposedly the best in the world, because it is supposed to enforce international law, and international law normally escapes enforcement. So the only reason it enforces is because of retaliation. So, but yes, for the developing countries, despite the problems that they face in accessing this mechanism, and there's lots of problems, there's enough research on that, the good thing is that to some extent it has leveled the playing field. And I add it is to some extent, but that some extent is quite good. So, for example, India has always said, oh, we uphold this, the rule of law in the WTO, and also it is promoted by this dispute settlement mechanism. So, definitely it is good for the developing countries in that sense. And you can see that a lot of the developing countries are now using it. In the beginning it was not so, but slowly they are coming up, even if it could be made better. But that making better of it depends again on consensus. So issues like small claims procedures, issues like collective retaliation, have been proposed, but of course you require something like consensus to have them. So the current mechanism is good, but it could be better.
I just want to endorse what she says. Most developing countries will say that they've had a good time with the dispute settlement mechanism. 90% of the complainants happen to win the cases. Complainants, not if you're a defendant. And that is the case with the United States as well, which is why it's even more difficult to understand the current position. But anyway, James, you want to answer the point?
Nothing much actually. So if you look, actually changes. You quoted some kind of a dynamic inconsistency problem. The situation which was prevailing at the time when you signed the treaty will not be the same when you really want to relook at the treaty. So the United States is no more a major exporter, as it was 20 years ago, and some of the advantage has shifted to China. So my own feeling is that they are trying to rebalance the system. They want to make sure that they had some kind of an idea about the WTO panel system. They did not even call their system a court, so it was actually kind of an ad hoc body. But nowadays the WTO legal system has actually become a judicialized system. So they really want to go back to the GATT days, where the power game, the power diplomacy could have triumphed over the rule-based system. So my own feeling is that it is actually kind of a rebalancing exercise, but I feel that the United States will have abiding faith in the system.
Professor Ranjan?
Yeah, very quickly on the developed versus developing countries and whether they're stopping developing country exports to developed countries. Yes, there have been many cases where tariffs have been imposed, etc. But then we should also remember that developing countries are also doing the same. There's a larger point which I want to make, that in all these debates and discussions, we are still inspired by the 1970s romanticized version of new international economic order, of looking at everything from the global north and the global south point of view. I'm not saying that analytical lens is redundant, it still has its value, but if we keep using that lens for every single debate on trade, then we might not go anywhere, because the times have changed. You look at food security, the countries which are opposing India's food security law are also developing countries. Pakistan is concerned about India's food security law because Pakistan feels that India will procure the grains, and then if it is not able to offload in the domestic market, it will be dumped in the international market. Now, whether there is empirical evidence for that or not is a separate issue, but there is a concern. So I think this is something which is important to highlight. I can't resist the temptation of reacting to what you mentioned, because I teach rules of treaty interpretation to my students. And I think it's very fascinating to hear from a former WTO panelist of how the VCLT is dealt with. It's a fundamental rule of treaty interpretation that you have to start by looking at the ordinary meaning of the words used. You have to look at the text, you have to look at the object and purpose, you read the preamble, you read the context.
Correct.
But that's not the end of it. Then there is 31.2 and 31.3. And you cannot only look at the ordinary meaning and not go beyond that. Now, the example which you gave of lex specialis, for example, let's assume that there is a human right norm and there is a WTO norm, and there is a direct conflict between the human right norm and the WTO norm. The first thing that you need to do as a panelist is to try to resolve that conflict and read the two norms in a harmonious manner. If reading the two norms in a harmonious manner is not possible, then of course the decision will be in favor of the WTO norm. But to say that we will not even make an attempt to construe the two norms in a harmonious manner is actually not following the customary international law and rules of treaty interpretation.
No, I get that. The trouble with that is, again, we're having an honest discussion. Most of the disputes would be about anti-dumping, subsidies. It is very specific.
Yes.
I'm not talking about dolphins and shrimps all the time. See, in the WTO, most of the things are about TBT provisions, SPS provisions, labeling provisions, genetically modified food, but as covered by TBT. Those are highly technical, highly specific. So there are going to be a handful of cases where, I'll be required to look at something else other than WTO law. And mind you, WTO now has been in existence for quite a while. So there is past precedence that I have to look at. Although the appellate body keeps saying each case is different, blah, blah, blah. The fact is, you are given past precedence. It's not easy to ignore.
Even in TBT cases, for example, the clove cigarettes case, etc.
Correct.
We can always look at right to health and other.
Oh, yes.
law.
Because it's embodied in the TPT.
I know, but even if it is not embodied in the TBT agreement, it does not stop if you are honestly following rules.
We'll have lunch.
Yeah.
We'll have lunch. No, we'll have lunch on another date. Not today, I have to go for a class. But really, I want to do this because there is another problem, and I'm going to finish with that. Chairman's prerogative. So, the language in the preamble is not relevant. That's the other problem in WTO law. I'm bothered about the operational provision. Your preamble talks of the land of milk and honey. Who cares? I'm bothered about the operational provision. But we'll have lunch, okay? So thank you very much and thank you for staying, Ambassador.